So thank you again for coming tonight to join Landcare Victoria for a conversation about what it means to be an incorporated or unincorporated entity, and perhaps to have a conversation about your circumstances and how you might make a decision around the legal status or making a change in the legal status for your organisation. So I just want to clarify that tonight is for a Victorian audience. Some of this will be relevant more broadly, and I know that we've had quite a few different registrations with interest in this space. We'll likely finish well before 7 o'clock, which I'm sure everyone will be happy about, but have left plenty of time in terms of a conversation and question and answer at the end. So I would like to start by acknowledging the traditional owners of the lands on which I'm meeting from today. So for me, that is here in Naarm, Melbourne, and I will recognise the Eastern Kulin Nation and pay respects to their elders past, present and emerging, and to acknowledge their right to self-determination and the leadership shown around caring for country. I'd also like to recognise any Aboriginal and Torres Strait Islander people present here today. So I am Claire Hetzel, the CEO at Landcare Victoria, and I'm sure we've got many people who have come to some of our other webinars as part of the Advancing Landcare Capacity Development Series. So hopefully you're also familiar with our team here. So we've got Anna Pimenta, the Landcare Development Coordinator, and Amanda Grace, our Office Coordinator, who has probably connected with some of you in our membership over many years of her time at Landcare Victoria. And tonight we're really happy to be joined by the expertise from Maddox. So we have Ron Smuka, who is a partner, and Nick Worth, one of the lawyers there, who'll be able to provide some really detailed information and hopefully help with the question and answers that you might bring to today's webinar. I'd also really like to say thank you to Maddox for their in-kind support of tonight's webinar. It really is through these partnerships that we're able to turn the funding, the little seed funding that we do get from our partner at the state government, the Department of Energy, Environment and Climate Action, into these offerings for our membership. So thank you to Maddox and to DECA for their support for tonight. So tonight is a meeting, a Zoom meeting, not a webinar, which was one of the last that we ran. So tonight you will be able to put all of your questions and comments into the chat function. So just down the bottom, you'll be able to see the controls there. You can click on that little speech bubble and be able to type in there and see some of the information that our team at Landcare Victoria will also be sharing through the webinar. It'd be really handy tonight if you manage to keep your microphone on mute throughout the webinar. So we've got almost 80 people attending so far, and we had registrations of up to 180. So it really would be fantastic if you can help us out there. But we are after your questions. So please use the chat function and we'll try and answer as many as we can as we go along. We'll save some of the juicier ones that are more relevant to Landcare groups and networks more broadly so that we can have a bit of a Q&A at the end. And I will note though, if something gets really niche and specific to your Landcare or environmental volunteering group, we will potentially take that on notice and recommend that you contact us on the team at Landcare Victoria after the webinar just to talk that through in more detail. And with that, I'm going to hand over tonight to Ron and Nick to take us through the content around incorporated and unincorporated status.
Claire, thank you very much, and welcome to everyone. I'd also like to begin by paying my respects to the traditional owners of the land on which we meet, which in Nick and my case is the Wurundjeri people of the Kulin Nation. And I pay my respects to their elders past, present and emerging. We are grateful for the opportunity to participate in this seminar. Landcare is a cause which is very dear to both Nick and my heart, so it's a welcome opportunity to give back. I also encourage you to take the opportunity to ask questions. We will do our best to answer them lucidly and hopefully healthily. Finally, before I begin, I'd just like to acknowledge the hard work of Nick and our colleague Emily Kidd in putting this presentation together. And I think that they've done, and hopefully you agree, an excellent job. So because it is a cold winter's night in Melbourne, I thought I'd start with a story. In 1892, a London bootmaker called Aaron Salomon decided that he was going to restructure his business affairs. He transferred his successful and long-standing leather business to a joint stock company, the shares in which were owned by himself, his wife, his daughter, and his 4 sons. What happened next was complex, and because this is a story ever so slightly tragic, Aaron Salomon's successful business became less successful. His creditors started circling, and a liquidator was appointed to Aaron Salomon and Sons. The liquidator claimed that he was entitled to recover property of Mr. Salomon himself for the benefit of the creditors of the company. Mr. Salomon had a very different view. One of the principal arguments that the liquidator put forward was that the company was in fact a sham. All Mr. Salomon had done was move his business to another business which he controlled, and therefore it was essentially the same thing. Ultimately, after about 10 years of litigation, the matter came before excuse me, the House of Lords in London, in England, which was then the highest court. And the House of Lords decided in favour of Salomon, Mr. Salomon. His assets were his assets, and they didn't belong to the creditors of the company. The death of Aaron Salomon's commercial dreams accordingly received a kind of legal immortality. His name is forever synonymous with what lawyers call the separate legal entity doctrine. That is, the separation of the affairs of the incorporated entity from the real people who make up that entity. And it's, in a very real sense, the legacy of Aaron Salomon that we're looking to explore tonight. Because what we lawyers refer to as incorporation, and what you will know as a company or an incorporated association, is really another kind of legal fiction. What the law says is that we will create a legal person that is distinct and separate from its officers and from its members. And we will invest that legal person with all the rights and abilities of a natural person. So an incorporated entity, be it, as I said, a company, be it a incorporated association, be it, if you're in the country, one of the old farming cooperatives, any one of the other kinds of body corporates, are legal people. They have the right to sue and be sued. They have the right to own their own property. They have the right to contract. And most importantly, the liability of the members of those entities is limited in a very real sense, so that the company can trade without exposing the members to any liability. In the context of volunteer organisations, incorporated entities have two other real advantages, which aren't often spoken about, but have a really very clear role to play. The first is that incorporated associations have perpetual succession. So they will continue, notwithstanding the fact that members change, committees of management come and go, and people can't actually remember what happened in the past. The company goes on, or the corporation goes on. The second advantage of incorporation, as opposed to other forms of organisation, is that it imposes on all people who are involved in that corporation very clear accountability and very clear governance arrangements. So people know exactly what their rights are and what they're supposed to be doing. The idea of a separate corporation is not necessarily a new one, but in modern law, there are fundamentally three different types of company or corporation which people get to choose from. The first is the company limited by shares, where the ownership interest of the members is measured by the shares they hold in that company. Although they can be used for not-for-profit activities, they're most commonly used, obviously, for commercial activities. So I mentioned them for completeness, but we're not going to spend too much time on them tonight. The second kind of body corporate, which is more familiar in the not-for-profit space, is a company limited by guarantee, where the membership doesn't hold shares. They become members on the promise that they will pay a limited amount in the event that the company becomes insolvent. But otherwise, there's no particular ownership interest by the members. And the law now imposes very real restrictions on what companies limited by guarantee can actually do. In particular, they can no longer pay dividends to members. So they are a perfect vehicle for a not-for-profit. The third and the increasingly common form of corporation is the incorporated association. Until about 1984, it was common for community organisations to be organised simply as clubs, as unincorporated groups of individuals who come together for particular purposes. For a variety of reasons, some of which we'll discuss shortly, that was seen as less than optimal. So in 1984, most of the states of Australia passed legislation which allowed community groups to incorporate and become separate legal entities. Since that time, the number of organisations that have been incorporated under that legislation has grown significantly. And indeed, there are now some very significantly, there are now some very substantial organisations that are incorporated under that Act. In recognition of the fact that this area was no longer the local netball club or the local football club, in 2012, Victorian Parliament completely overhauled the law relating to incorporated associations. But it is still a very quick, very easy, and relatively rule-free way to obtain the benefits of incorporation. And we'll deal with each of those particular aspects later on. The one thing that I wanted to make clear, because there may be some misapprehension around this, and particularly an organisation like Landcare, the fact that a unincorporated association or a group of individuals with a common purpose become a member of Landcare doesn't of itself give that group of individuals or that club or that association the benefit of being incorporated. Yes, you have the benefits of being a member of Landcare, but you are still a group of individuals with your own responsibilities and your own exposures. So to the extent that any of you are taking comfort from the fact that your membership of Landcare gives you benefits, yes, it does, but it doesn't give you complete protection. As I said, the model of the incorporation most likely to be relevant to you is incorporated association. We'll talk about companies limited by guarantee. And as I said, there may well be other models that some of you have questions about. I think we're on the next slide. Okay. So we've talked about some of the benefits of being incorporated. What happens if you're unincorporated? The law has struggled for a very, very long time with how to deal with unincorporated associations, with clubs, with groups of individuals with a common purpose. And I think the high-level summary of what is probably 300 years of legal endeavours is a highly unsatisfactory outcome. If you're an unincorporated association, you actually can't make contracts in your own name. So if you are the, land regeneration, the Colac Land Regeneration Association, I'm not actually sure if that's a thing, but it is for the purposes of tonight, which is unincorporated, you can't enter into a contract in that name. One of the members will have to be the party who signs up with all the attendant responsibilities that will go to being a party to that contract. Just as importantly, an unincorporated association can't hold property in its own name. And how that incorporated association actually ends up holding property or having the access to property will depend very much on the circumstances. It'll either vest in all of the members, it'll vest in some of the members as trustee, or it won't vest at all, in which case the gift or the transfer will just fail. Also, if you're in an unincorporated association, you can't be named as a party to legal proceedings. Therefore, in order for an association to attempt to defend its rights or assert its rights, the individuals will have to be joined, the individuals who constitute the association will have to be joined as parties. And finally, there's no general limited liability for members. And again, the extent of the liability of members for the action of an association is subject to the facts of the particular case. So one person might be liable, all of the association might be liable, the committee of management might be liable, no one might be liable. So I think the summary of all of this is that one of the great problems of being an unincorporated association is that you live in a very grey legal world. And that has two consequences in particular. The first is that, and I think this is important for, likely to be important, at least for all organisations which have a shared purpose, is that your ability to leave a legacy is impacted, because all of the good work that you do, all of the property that you assemble, all of the funding you get, all of the grants that you get, all of that is at risk if it's not done strictly correctly. And even if it is done correctly, it's subject to challenge. An unincorporated association has very real problems in delivering what it's built to the next generation of members. The other related problem with being an unincorporated association is that, as you've heard, no one's quite sure what the rules are. And the cases are littered. And I think littered is actually the right adjective, with examples of vicious disputes between members of unincorporated associations and even the committee of management of unincorporated associations about what their rights and what their entitlements are. The advantage, as I said, of being an incorporated association is that everyone is very clear about what the rules are. And that gives you the basis of a stable organisation to go forward and to do your good work. I know it sounds like I'm doing a sell job for incorporation, and that is largely because I am. In terms of the financial implications for remaining unincorporated, for the same reasons it's difficult to contract, it's very difficult to obtain insurance. We'll talk a bit further about Landcare's insurance program shortly. As a general proposition, getting insurance for the activities of an unincorporated association is very, very difficult. Similarly, unincorporated associations do not ordinarily have access to government grants. The requirement, if the grant is available at all, is that that grant be auspiced under an unincorporated association. And while there's no legal requirement to keep accounts, one of the other disadvantages of being unincorporated is it's not quite clear what your tax requirements are, and that uncertainty can be difficult as well. So, next slide. So what it means to be unincorporated as a Landcare Victoria member, and the Landcare Vic people should feel free to interrupt at some point, is what it doesn't get you, as we said, is automatic incorporation. So you're on your own on that point. Landcare Victoria does have an insurance program for some activities of member groups, but that is by no means universal. And there are likely to be circumstances just in the everyday life of even a medium-sized organisation which will not be covered by the Landcare Victoria insurance program. Landcare Victoria will auspice um, uh, grants for member organisations. The difficulty with auspicing is probably twofold. The first is that ordinarily that auspicing imposes at least some obligations on the auspicing body. Which has the consequence that they will be very interested in how the grant is dispersed and applied. And there is a corresponding lack of autonomy on the unincorporated member about how it deals with that grant. So to be able to get a grant in your own right obviously gives you a degree of autonomy which auspicing won't do. And as Anna just said, the impact of auspicing is that effectively Landcare takes on the legal obligations and basically stands as a kind of surety or guarantor for the unincorporated member, which, as you'll understand, is probably not a desirable position for that for Landcare Victoria to take as a general proposition. At that point, no, I'm done, Nick. Thank you. At that point, I'll stop speaking and pass over to Nick.
Thanks, Ron. Look, Ron's touched on a number of points, pros and cons really for each option so far, but we're just going to, for the next few slides, reiterate some of those points and have a look at some of the practicalities of each option. So to start with, to look at an incorporated association, which we understand that incorporating as an incorporated association is likely the most appealing means of incorporation for many land care groups. I think this is reflected in the numbers. I think over half of the members for Landcare Vic, or around half, are incorporated associations. And it's generally a good option for not-for-profit groups, which are relatively smaller in scale and sometimes complexity, and also operate within the one jurisdiction. And in this case, that would be Victoria. Entities that are incorporated as an incorporated association would be incorporated under legislation that's referred to as the Associations Incorporation Reform Act, IC 2012. I think it's been updated to 2023 now, and regulated by Consumer Affairs Victoria. Incorporated associations are required to operate as on a not-for-profit basis and have a minimum of 5 members, as well as a set of rules that governs the association. And that could be either the model rules, and incorporated associations can incorporate having adopted the model rules, or with a bespoke governing document instead. Incorporated associations also have a governing committee that would meet annually, and that is, I guess, the equivalent of a board of directors. Associations are also divided into different tiers, and that will correspond with different reporting obligations. Tier 1 associations, as a lot of you may be aware, as an example, have a turnover of less than $250,000, which will, from 1 July 2024, that will increase to $500,000 threshold. And those associations would need to keep financial documents that record and explain entities' transactions, financial position, and allow for preparation of financial statements. So some of the pros, as Ron has already touched on, it's that incorporated associations are probably the generally regarded as probably the most simple and relatively inexpensive means of incorporation, especially for not-for-profits. Its setting up is relatively cheaper as well compared to a company limited by guarantee in most circumstances, especially where the corporation is adopting the model rules. They can be by a few $100 at incorporation, less than a company limited by guarantee. And very importantly, incorporated associations are considered a separate legal entity that can enter into contracts, be a party to legal proceedings, and importantly protect its own interests in that regard, and its members have limited liability. And as discussed, that generally allows the organisation to operate with more freedom while reducing risk. Also, as you'd be aware that as a not-for-profit organisation, incorporated associations are eligible to register with the ACNC and be a not-for-profit, making the organisation generally exempt from income tax. Some of the limitations is that it is a less known legal structure, and that can that even though it is a distinct legal identity, it can still result in some difficulties, including contracting or seeking funding, especially if funding is sometimes only available to certain corporate structures, such as companies. It's been known to happen in some instances, but also from a legal perspective, the legislation that governs incorporated associations, while there are rules, and it's definitely a step up from being unincorporated in that regard, the rules are not, they haven't been tested as much as companies. So arguably there's less guidance and certainty around complying with rules, even though they are rules, and it's important to comply with them anyway. There's sometimes more ambiguity. Other limitations are not for, obviously this is not a limitation for everyone, but incorporated associations can't operate outside of Victoria if they're incorporated under the Victorian legislation. Also, if you are in the business of trading for profit, incorporated associations are also not the best structure for you. Just briefly, companies limited by guarantee is also a very popular option for incorporation as a if you're a not-for-profit. I understand that there are some members of Landcare Victoria which are companies limited by guarantee. And what this means is that you're a company that's incorporated under federal legislation, the Corporations Act, and that's who you'd be governed by, including ASIC, as well as the ACNC if you are a registered charity. You'd also be required to have a board of directors, the equivalent of incorporated associations committee members, and public companies, even companies limited by guarantee, are required to also have a secretary. Directors are appointed by the members, and they would owe the directors would owe legal duties to the companies and to the members, and also complying with their directors' duties under the Corporations Act, as well as general law. Members of companies limited by guarantee agree to, this was the idea of members limited liability. So when when a member becomes a member or incorporating at the point of incorporation, members will contribute a defined amount, which might be nominal. It could be $10 or $100. And when the company winds up its debts, and its debts are greater than assets, the contribution is limited to what that amount, and that's the limit of what members stand to lose. Some pros around companies limited by guarantee is that it is a very well known and widely used legal structure, especially for not-for-profits, and in particular where an organisation operates across multiple states rather than in one state. And because it is a better known entity and better understood entity, it may be in some circumstances easier to receive funding and perhaps contract with other parties because of the certainty of that structure. There's also the benefit, of course, that companies limited by guarantee are also distinct legal entities, and they have, and of course, the limited liability of members, meaning that when the companies wound up, as I said earlier, and Ron has touched on, the members' liability is limited in a very real sense. It can be a very cost-effective option, and and still has limited reporting requirements, especially for a small company. And importantly, being a company limited by guarantee does allow you to register as a charity, subject to eligibility, of course. And it is a well-trodden path for registered charities being a company limited by guarantee. And another point of difference for companies limited by guarantee that are charities is that there's no dual reporting requirement. So companies limited by guarantee would only need to report to the ACNC once a year, rather than dual report to ASIC 2. And even though companies limited by guarantee need to comply with the Corporations Act, in some circumstances, the ACNC legislation applies or replaces some of the Corporations Act requirements for companies limited by guarantee. Some cons is that, or limitations rather, it's not always the cheapest option. There is generally regarded to be more administration and regulatory compliance involved. And there is also arguably more complex and onerous statutory duties of the company. Not that incorporated associations don't have that. I think that generally committee members or the board of an incorporated association have responsibilities and are deemed to be held to the same standard in some circumstances, especially in larger organisations, as directors. It's the companies limited by guarantee have very clear and onerous obligations on directors. And then lastly, as we've discussed, remaining unincorporated basically means that you're not governed by any public standards, nor is group that you're part of a legal entity or identifiable in a legal sense. You would consider it a group of people who've come together to pursue a common purpose. And as Von said, I think it really captures it that if you're an unincorporated body, you're really operating in a very grey legal world. In saying that, there are pros if it is a suitable structure for you, meaning that there's, theoretically great flexibility. There's no requirement to adhere to legislative rules, and you're generally not restricted when you're acting for a common purpose. It could also be, it is more cost effective. There are no setup fees and annual fees involved, like the other organisations being incorporated associations, companies limited by guarantee. There are also benefits being unincorporated. This applies specifically to Landcare Victoria members, being the auspicing benefits and benefiting from insurances. And lastly, not necessarily well known, but unincorporated groups also have the ability to register as a charity and subject to eligibility. Also with the ACNC and BA not-for-profit, making the organisation exempt from income tax. As we've discussed, you don't have any liability, so members are exposed. That's probably the most major limitation of unincorporated associations or groups, is that members are generally exposed. They can't enter into contracts in their own name, apply for grants, hold property, and also sue to protect its interests and be party to legal proceedings. Even though there are benefits being an unincorporated member of Landcare Victoria, it may not be for you, for everyone, sufficiently comprehensive in every situation. Now just moving on to some of the practicalities of incorporating yourself. So for the two examples, we've actually looked at incorporating as an incorporated association, as well as incorporating as a company limited by guarantee. In both instances, the process is relatively simple. To be incorporated as an incorporated association, the group would need to first ensure that they meet all of the requirements for incorporation. That includes that the group has 5 members minimum, and they do not operate for a profit. The group would also need to choose their name, decide if they'll be governed by the model rules or their own rules, which makes a difference at the point of incorporation as to the fee for incorporation. Vote on whether to incorporate, and if the outcome of the vote's positive, an application will be lodged, and that application is available on the Consumer Affairs Victoria website. Incorporating as an association, $477 if an incorporation uses their own rules, or $79.50 using Consumer Affairs Victoria's model rules. For companies limited by guarantee, it's with a different institution being ASIC, who you'll register with. You'll need to have a company constitution or use the placeable rules under the Corporations Act. Consent to act for each of the office holders and members in some circumstances. All these details, they'll need to be submitted to ASIC in a particular form, and then a fee that applies it depends on whether you're not for profit or not, or what you consider to be a special purpose company. And if you're a special purpose company, which includes being a not-for-profit or not operating for a profit, this fee is reduced to $61. So even though the practicalities might be not that interesting, I think that it's important to have everything in the one place that you can see the two different processes and the practicalities of actually taking the next steps if you were to incorporate. And so next we were going to touch on a case study which looks at the particular context being if you're an unincorporated or a incorporated association and a member of Landcare Victoria.
Okay, thank you, Nick. I was just watching the chat flash across the screen while Nick was speaking. I'm in awe of Amanda's keyboard skills, I have to say. Okay. So, CMY is an organisation that operates in rural Victoria with a mandate for the preservation of native bird life. A donor has decided to bequeath a piece of land to the members of the organisation. My apologies for the typo. There's subsequently a dispute on the management committee over the use of the land. During the dispute, the majority of CMY's committee members resign. And just to complete the trilogy of disasters, while the dispute is ongoing, the land has been left unfenced, and a number of bird watchers enter the property and fall into a mine shaft. Okay. So dealing with those two, that fact scenario from the point of view of whether CMY is incorporated or unincorporated, and dealing with the unincorporated first. As we said, I've said a number of times now, an unincorporated association can't hold property in its own right. The usual way in which that is circumvented, particularly in the case of real property transactions, is that the property is vested in the committee of management as trustees to hold that property on behalf of the members generally. So let's assume that that's happens here. The difficulty with that is that each of the members has an ownership interest in the property, and generally the agreement of all of them is needed in order for there to be any dealing with the property. So if there's a dispute in the management committee over the use of the land in an unincorporated association, the likely outcome is either deadlock or you're off to the Supreme Court to try and sort it out. A similar thing happens where there's a majority of the committee resign. They may resign as members of the organisation, but they will not resign as members, as owners of the property. So you'll either have to convince the resigning members to transfer the property, which has a number of consequences, including potentially stamp duty, or else the organisation is faced with the situation whether its major assets is owned by people who are no longer members of that organisation. In relation to the unfortunate experience of the bird watchers, the owners of the property, being the committee members, will have what's referred to as occupier's liability in that circumstance. So in the event that the bird watchers are injured and they decide to sue, they will sue the individual members of the committee who actually own the land rather than the association. In an extreme situation, if there are members of the organisation who aren't on the committee but who have assets, and litigation always tends to follow the money, it may well be that other members of the association are sued as well. So compare that to the situation where you have CMY as a company limited by guarantee. Okay. So the transfer of the land from the donor will be to CMY Limited, which will hold it in that capacity. So there will be no ownership by the members of the committee or by the other members. It will be owned by the company. If there's a dispute on the management committee over the use of that land, there is a board in the Constitution which says that resolutions can be passed by an ordinary resolution. So if you don't need everyone to agree. And if there are a continued dispute, then there is a mechanism for a spill of the board so that a new board can be appointed, or else there are very clear rules about how you can get that dispute into court. If the majority of CMY's committee members resign during the process, again, the Constitution provides very clearly how the board will be re-elected, and the fact that they've gone the fact that the board has resigned doesn't impact the ownership of the property in a company limited by guarantee. And the final circumstance, the final situation where the bird watchers sue, they will sue the company. The members and the members of the committee or the board of directors will not be liable for the loss or the damage, injury suffered by the bird watchers. As I said, there are some very clear advantages in that scenario in being incorporated. So just moving, mindful of the time, to the key takeaways. Okay, just in case we didn't make the point often enough, being a member of Landcare Victoria doesn't mean your organisation is incorporated automatically. There are advantages of, you will get some benefits if you're an unincorporated association, but not all of the benefits of being incorporated. As Nick quite rightly said, you do not need to be incorporated to be an income tax exempt organisation. That is clear. But there is a range of other benefits that do flow from that. The final point is fair. Incorporation may not be right for all organisations, but I have to say, in my experience, and speaking to you as the acting president of a very small bowls club, I actually can't think of a situation in which incorporation wouldn't suit an organisation. Obviously, there will be some circumstances, but as a general rule, incorporation is something that all organisations should very carefully think about. And that takes us to the end. And we are now happy to take some carefully moderated questions.
Thank you, Ron, and thank you, Nick. I think one of the comments I really like in the chat is that an appreciation for the really clear way in which you delivered what is actually some really complex information for our groups. So thank you so much for that. And one of my kind of highlights that I think is important, and which perhaps gets missed in the consideration of the pros and cons, is that concept of legacy. And the fact that you're actually creating a vessel that will carry on no matter who the committee members are when you start to look at incorporating in some legal sense. And I think one of the things as a peak body we do know is that there is an ebb and flow to the on-ground action that is land care. And it's driven by passionate volunteers who care for place. And those volunteers and their lives change over. And so committees can be really strong and have a 10-year period of amazing action, and then they might have a period of needing to kind of pause and reconsider before they pick up new committee members. Having that kind of entity to carry on or to have a structure to does enable that to happen without some of the gaps in the handing on of knowledge that might happen in unincorporated kind of situations. So I guess I do thank you for that kind of long-term view or the long lens on what it may be as a benefit in terms of the legacy piece around making these decisions. So there's a couple of questions that I'd love to, one we can speak to as Landcare Victoria, but particularly lean on the expertise from Maddox to be able to answer. And I'll start at the top. So one of them was a questions about what do you mean by property? Is that just like physical land, or is it also referring to things like spray trailers or tools or other kit that Landcare unincorporated groups may have, or incorporated groups? Is that something, Ron or Nick, that you can speak to?
Yeah, it's all property. So whether it's tangible or intangible, real or personal. So everything from the donor property in our example through to, spades and augers, through to vehicles, and to intellectual property such as copyright, trademarks, brand names, those things. All of it all of that sort of will be owned by an incorporated association. But as I said, the unincorporated association, the individual members or some of the individual members or some combination thereof will own that, not for the benefit of the organisation, sorry, in their own name rather than in the name of the organisation. I think I completely butchered that answer, but hopefully there was some kernel of truth in there somewhere.
Yeah. And I think you're right in saying that it's not just land, it's property more generally, and that there is this kind of nuance around an individual in an unincorporated group holding some responsibility on behalf of a collective versus it being held by a separate entity in its own right. And so there is a distinction there that in practice probably doesn't mean very much, but legally does have huge implications when there are tricky things that come up or conflicts, as you said. And I think you said littered. There's this littering of kind of disputes for committee at the committee level that reflect that in your practice.
And I would just actually on that point, going back to the legacy comment, but also this one, the heartbreaking part of this area of law is to read the cases where organisations which started off with the best of intentions just blow themselves apart on these disputes. So they are salutary lessons, unfortunately.
And I think it speaks the duality of the strength of Landcare, which is the human system, the human infrastructure that delivers this work. And the weakness is the human infrastructure in some ways that delivers this work, because it does ebb and flow in terms of what that means in personalities and scales in sort of how they work. But I truly do believe it is the strength of what Landcare is. I guess there's a question here, and it starts to lend to kind of the role of Landcare Victoria. And so we have articulated some of the services or member services or reasons for signing up for Landcare Victoria as both the umbrella insurance policy that we do negotiate on behalf of the 600 plus groups in Victoria. And that covers Landcare groups, whether you're incorporated or unincorporated, so it doesn't impact your ability to access the insurance. And in fact, one of the purposes of us existing as that umbrella is to make it possible for small entities to begin and form and to be able to take action without having to take on the full kind of steps towards becoming an incorporated association and setting up to be able to receive grant funding. So there's a couple of questions here around the role of an auspicer. And so that's when we sponsor, for an unincorporated Landcare group, Landcare Victoria can allow you to access grant funding via our legal entity. And it does mean that we take on some of the risks and responsibilities for that grant. Historically, there's been quite a kind of very trusting relationship between Landcare Victoria and its member groups, and I imagine that will continue. But in some instances, we are aware that perhaps groups operate thinking that our incorporation number or our legal status is theirs. And I think what we're trying to make clear is it really is important that you check your own name with Consumer Affairs Victoria to see if you're incorporated in your own right, or contact us so we can help clarify whether perhaps you've thought you've incorporated and it might have even be ink tucked on the end of your name, and you might have an ABN registered as an other incorporated entity. There's some really confusing things that we do see in the membership. Contact us, and Amanda, our amazing, I think office coordinator is just the worst title for her, but amazing support person for our member groups will help you to unravel the reality of your context. There was a question here around grants and whether, being incorporated helps or hinders your ability to access grant funding. I would say overall it will benefit you in being able to access grants and do it without any third party. You don't have to follow our member grants policy. You don't have to follow our expectations around timelines for reporting and getting things signed off for us. You can just do it yourself. And that would be a benefit of becoming incorporated, to be able to access a number of grant funds. In the Landcare world, I know there is some flexibility around accessing some grants that is a benefit of our collective efforts to advocate for a smooth system. And so some grants are available to unincorporated groups to access in their own right. There's a question here though, and I'll flip it over to you guys, which is, I'm not sure, and you might say you can't answer, is around sort of the pros and cons of having an Australian business number. And we're straying a little bit off the incorporated, unincorporated route here. So Ron and Nick, please feel free to say that's not something we want to kind of go down as a little bit of a rabbit hole.
No, happy to answer it. I mean, I think it's actually a separate issue. The ABN is principally around tax legislation, and in particular GST registration. Whether or not it's of advantage to you depends on a number of things, including your turnover, as to whether you're required to register for GST or not. But it's not of itself an advantage or a disadvantage, it's just a thing.
Thank you. So there's, I guess, some questions being raised around Landcare Victoria's insurance program. And so the insurance program is built specifically for Landcare groups and environmental bullying groups in mind. And we've run a whole separate hour-and-a-half webinar around risk management and insurance for Landcare, which kind of articulates the things that are in generally. And we've got 3 main policies that are supporting our groups around public liability, volunteer accident cover, and the association liabilities. So it does pick up a lot of cover for unincorporated committees via our insurance program. But we don't have insurance for things like assets or workers' compensation or some of the other categories that are kind of more nuanced depending on your group. So we do have a summary available which has quite a lot of detail to it to all paid up member groups. There's an overview publicly available on our website, and we also provide the full policy documentation. And Anna Pimenta here tonight is the contact person for all insurance related questions at Landcare Victoria. So there was a question here about whether Landcare Victoria supports the reporting to Consumer Affairs Victoria on behalf of its member groups. And I will say that very clearly that we don't report on behalf of member groups to Consumer Affairs Victoria. If you are incorporated or you're thinking about incorporating, there will be that kind of responsibility to maintain updates to Consumer Affairs Victoria on your own behalf. I will note in the slide that the fee for using the model rules was a little bit lower than the current fee, which is $79.50. So thank you to Belinda for updating that in the chat. There was also some questions around whether you can be an unincorporated member group and travel through registration as a charity, which was the webinar we ran, I think, just last month. And the answer is yes, you can go through and apply for registration with the Australian Charities and Not-for-Profits Commission to access that tax exempt status as an unincorporated group. There are a couple of things you have to set up that might not already be established for your groups, like some really clear purposes, but there's some templates and tools available to help groups navigate that process. So it is not a requirement of registering as a charity that you become incorporated, just to make that clear. And then there was a question here that's a much bigger question, which is around the role of networks supporting smaller groups. And I speaks to the heart of kind of some of this red tape stranglehold that is starting to make it harder and harder to aggregate and get together and collectively care for the places in which we live and work. And I guess we're hearing you. We understand that the ACNC kind of the changes at the ATO around income tax reporting and what that might mean for Landcare groups in becoming registered as a charity with the Australian ACNC is actually really kind of mind-blowingly, oh my goodness, this is too much information and I just want to get on and do the business of Landcare. And when you start to add some of the information about decisions of incorporated and unincorporated, and maybe some of the other red tape pieces that are kicking in around reporting on grants, it does start to feel harder and harder to do the business of Landcare. One of the strengths of Landcare in Victoria is our network, peak body, network and group structure. And I would say there is such a role for networks in our system to, I guess, understand some of the things that they can pass on as information to those smaller groups. Amanda's made it clear in the chat that we do have some supports and understand that some groups are going to wrap up because they're at that point where there's just not enough oomph in the committee to be able to navigate some of this red tape. We don't want to lose any groups from the Landcare system, but there is always a little bit of a flux. So I think last year we had 20 groups who dissolved or merged or ceased to operate. And we also had more than 20 groups who joined the Landcare system. So there is this natural kind of senescence that will happen. What we're concerned about is that these pressures will accelerate the loss of groups. What we're hoping that we can see with networks, and that we absolutely are wanting to support as a peak body, is that we can find a way to tuck the smaller entities under a bigger entity so that volunteers can still take action on the ground, but there might perhaps be economies of scale that can be reached. It's probably going to be a change that requires a few conversations, and one that we will engage with our members council to open up around the role of networks and how we as a peak body might evolve our support and advocacy efforts to make sure that networks and groups are supported to continue to operate. So I guess it's not a clear answer of what do networks need to do to make sure they're supporting their groups, except to say, please do reach out for information, because if we can share that with the 62 networks in Victoria, and those 62 networks can share it with our 650 groups, then that's a way that we can disseminate the information in a way that makes sense, that can be contextualised, that creates a real face to asking and finding out what it means at the local level. So I guess there's a couple of links and resources that we do want to make available to people. Perfectly on the page here is some useful links around, one, the benefits of being a member of Landcare Victoria. What I'll highlight is that there is, if you've been using our incorporation details to access grant funding, but perhaps have bypassed the part where you let us know about that, we really do ask that you do contact Anna. That's part of her job. And we have a pretty light touch in terms of how we carry that risk. And that's part of a legacy that we have as another time that we continue to honour. But there is a member groups auspice grant policy and procedure with some steps that we do require groups to follow if they're using our incorporation details. And it really does carry some risks and liabilities for our organisation. And I'd say we don't want one group to tip the boat that impacts 650. So please do reach out and do due diligence around your kind of use of and reliance on us and our member grant services. We also have got some information from not-for-profit law about should you incorporate, and it's actually a really nifty sheet that just helps articulate the benefits and pros and cons here. So there's a fact sheet, there's a link there. And there's some consumer affairs information and model rules kind of sort of guides that are available. And the ACNC has that governing template for unincorporated groups as well. We also offer for you to get in contact if you're a member of Landcare Victoria, and note that at the moment, because of the ACNC issue and our renewal of insurance and membership, that it may take us a little while to respond, or a little longer than normal to respond to your queries, but they don't get lost. We will get back to you and support you as best we can. And to anyone with a network, and that's the Landcare facilitators, the committees, I just want to say thank you for coming tonight. If there's any way that we can help you disseminate information to support groups and keep those little ones on deck, then we really do ask you to reach out. A huge thank you to Ron and Nick. You guys have been ace to work with. I think that your understanding of groups and Landcare and ability to kind of get it and communicate it has been so valuable to us tonight. So I guess, did you want to say any last words? I'll flick back to you, Nick or Ron. before we close out for tonight?
No, other than to thank you for the opportunity and offer my best to all of your member organisations in navigating the red tape.
Thank you, Ron, and thank you, Nick. Huge thank you to the team at Landcare Victoria. You've got more than half of us here tonight. So as a peak body, we are as lean as it gets, and we continue to do what we can to support our membership. So I have to say, I reckon everyone here is probably a little bit happy that we're finishing just a touch early. Reach out and get in touch if we can help you. And thank you so much for caring enough to come tonight to listen to this information.